All right, so chapter 14. Now we'll be discussing real and personal property. So continuing from chapter 13, the discussion on property, however, two other types of property now. So let's first distinguish what is real property and personal property. So real property is land and anything that is permanently attached to the land. So when a house is built, the house is permanently attached to the house or to the land. So the house also becomes real property. If you buy a plastic 5,000 liter swimming pool at Walmart or Canadian Tires, that plastic easy to install swimming pool does not become permanently attached to the land. So you cannot call this as real property. But if you have a swimming pool built in your land, then built by concrete or any other types of materials, but it's built, it's going to be permanently there. Then you can call that swimming pool real property. Okay? Whereas personal property will be goods. Actually, here we are looking at chattels. You saw chattels in chapter 4 when there were torts related to chattels, trespass to chattels. Remember, assault and battery. Chattels is actually the legal terminology for goods. So chattels as personal property, they are any tangible personal property, any movable goods, any goods that can be weighed and measured. So your smartphone is a chattel and is a personal property. Your laptop computer, your water bottle, your earphones. So anything that is tangible that you can touch, anything that is movable, you can weigh or measure, they are personal property, known as chattels or goods. And there's another type of uh, personal property that is called chose in action. Chose in action is an intangible right. So I have a right. I have a right of a payment. Just get some water, sorry. So um, I delivered a service, let's say as a lawyer, and now I have a right to be paid. My client has not paid me yet. So this right to be paid is personal property known as chose in action. If you have shares of a company, excuse me. So if you hold shares of a company, you are a shareholder. The shares, they are an example of chose in action as well. Because the shares itself, the share certificate, is not the paper, the certificate itself is not, is only good for the right you can claim in the company, your ownership right. So shares, another example as chose in action. A check, someone writes a check to you. That check is your right to either cash out that money, that amount, or to make a deposit. Again, chose in action, because the check is just an instrument to give you the right. So those are two main personal property types. Well, we also have intellectual property, as we just saw in chapter 13. So let's look at those two types of property with more details now. Let's start with real property. So you already know real property is land or anything that is permanently in the land, attached to the land. The mineral rights. So if there are any minerals underneath your land, it doesn't mean you own them. Why? Because mineral rights in Canada, they have their own body of law. So as a general concept, there are exceptions, details, etc. But as a general concept, it is the federal government that owns the minerals under our land. Different from the US. I know that in Texas and in California, if you find oil in your property, in your land, you own them. So you can either sell or you can try to extract yourself. Okay, so that's different. But we own the land which is even below the surface, because we can have our basement there, we can build garages, etc. Except for the mineral rights that will have their own body of law. And now we look at states. By the way, states here, E with an E. So states, not states with only S, okay? So what are states? Well, the way I find to explain this to you is like this. So the whole Canadian land is owned by the federal government. The federal government owns everything. And actually, if there's any threat of invasion here, it is the federal government through the army that will protect us. So the government, they own everything. However, they give us rights for certain pieces of land. And those rights, they are known as states. So those states, they are actually rights we have. So we have rights of possession. And this right of possession is actually granted by the crown, is granted by the government. Okay? So when we say, oh, I'm the owner of this house, I'm the owner of this land. Okay, in the real world, we say like this. But legally speaking, we don't own our land. We have a right on our land. And this right is known as fee simple. So fee simple is the fullest right we can have in a land. Fee simple means we own the land. But now we have to go more technical, more legal. And as I just told you, being a fee simple holder means that we have the right to use the land as we wish, as long as we are complying with other laws, bylaws, etc. But we can use the land and we can sell the land to someone else. But again, selling the land here is actually transferring the fee simple rights. Because remember I told you, we don't own the land. It is the government that owns everything. And I'm not saying we are a communist country. No, no, no. It's just the legal mechanism. The legal mechanism was built under those states. Okay? Was built under this right, which is the right of possession, and transfer this right. So as I said, when we say we own a land, we actually hold a fee simple right, or we own a fee simple. There's another type of state that is called life state. So life state means you have the possession for the time of your life. But when you pass away, this possession goes back to the original owner. There are some properties here in, if I'm not mistaken, near Kitsilano. you can have a life state on them. So you pay a price that is lower, that is cheaper than a fee simple, but still you can live in that house, in that property for the time of your life. Okay? So why do you pay less? Because you don't have a fee simple. You don't have the fullest of the rights. You have only a life state. You have only the rights until you are alive. After you pass away, the possession will revert back to the owner. So the owner is still there. There's also another way to use this life state. So let's say I have a fee simple of a house, of a second house here in Vancouver, and I want my mom to live in that house. So instead of renting the house to my mom or transferring the fee simple to my mom, I can place a life state on the property for my mom. So my mom will live or will have rights in that property as a life state holder for the time she is alive, but after she passes away, possession comes back to me or goes to my heirs, to my estate, if I have passed away. So instead of transferring the fee simple, because if I transfer the fee simple to my mom, when she passes away, that property will have to be shared among my brothers and I. And this is something I don't want because the property is mine. I have the fee simple. So to protect my mom, I will give her a life state, but I will be also protected in terms of my ownership. Okay? So while being alive under a life state, do you have the same rights as a fee simple? Almost all rights, because you cannot sell the land, because the land is not yours. But you can rent the property if you want. You have to maintain the property. The only right you don't have in a life state, or the main right you don't have in a life state, is the right to sell, because you don't own the property. You do not have the fee simple. Okay, is that clear? All right. And the other type of state is a leasehold. So when the land is leased, is rented to a tenant for a specific period of time. A land can be leased for 10 years, for 50 years, for 1 year. But there are lands in the commercial field that are leased for a long time so that the tenant can make a lot of investments. They usually build a warehouse. They build a big, huge infrastructure around. So because of this, they want to be leasing for a long time. And this is also a state. So it's a right someone has on a property. They have the rights of a tenant. Okay? So this may sound a bit complex, but it is not. The way you have to look at them, the way you have to perceive them is that we have rights over property, legally speaking, and the rights that are similar to ownership will be fee simple. So when I have a fee simple, it means I can sell, I can rent, I can do whatever I want as long as it is not prohibited by law. Whereas a life state is very similar to a fee simple, except that I cannot sell the land and the life state ends when the life state holder passes away. And the leasehold state is the one that will end after the specific period of time that was agreed upon. There are other interests or rights over properties, and one that we usually call your attention are the easements. So easements are the ones that a person has a right to use part of someone else's land. So a portion of someone else's land can be used for a specific purpose. but they cannot get possession of that part. The best example here is BC Hydro, Telus, Shaw, Fortis BC. They have easements on several properties or most properties here in BC because they have a right to use the land beneath to pass their cables, their tubes, their pipes, etc. Okay, so they don't possess that part, that portion, but they can use them to have their infrastructure. Or we have the right of way. Right of way is when someone has the right to cross, but it's just the right to cross. You cannot park, you cannot build, you cannot stay there. You just cross. So let's say there's this house at a beach, and for me to have access to the beach, to the sand, I need to go through someone else's land. So this is an example of right of way. I cannot stop there, I cannot build anything there, but I have the right to cross. Okay? License is another easement example. So license is when someone has permission to use someone else's land. Shopping mall. So if most of you know Metropolis Metrotown, so that's the shopping mall in which everyone has a license to be there. We have an implied license to go shopping. We have an implied license to be there, shop window shopping, etc. However, this license may be withdrawn, may be revoked. So if we are not behaving well, the shopping mall patrons, they may revoke our license. And they would revoke and ask us to leave the place. If we don't leave, we would be trespassing. We would be committing the tort of trespass. So security guards could use reasonable force, not in excess, but reasonable force to expel us, to move us out of the mall because our permission was revoked. This is what happens in bars. So we go to a pub, to a bar, and if we drink more than we should, our license is usually revoked. We are invited to leave the place. If we don't leave voluntarily, security guards usually and kindly and friendly um, carry us out of the bar. However, if they use more than reasonable force, force in excess, causes harm, injury, they may be sued for battery um, because of the excessive force. Okay, but those are other interests in land. Another right that is very common in land um, is the restrictive covenant. Well, we discussed about this already in contract law. We discussed about this chapter 12 for um, employment agreements, specifically non-disclosure, competition, non-competition, and non-solicitation. And here, restrictive covenants, they are the same thing for land. However, they have a different use. When I say they are the same thing, I'm saying that they are also restrictions for whoever owns the land or the states in land. But they are restrictions. What type of restrictions are for land? For example, there's a building scheme. The developer comes up with a building scheme and decides to restrict through a restrictive covenant that land only for residential purposes or otherwise just for commercial purposes. So whenever you're buying land, when you're getting your fee simple, you need to look at the title of the property and look for restrictive covenants. Because if you find restrictions to build your house, you don't want to buy that land. or if you are looking for a land to build your warehouse for your company, you don't want any restrictive covenant that prevent you or restrict you for using that land for commercial purposes, for example. Okay, so in terms of ownership, in terms of fee simple, a fee simple may be held by two or more people. This is owning property together, when two or more people own property. And when this happens, there are two types of tenancy, as we call, two types of ownership. One is known as tenancy in common, the other is joint tenancy. It is important for us to know this because the consequences are different, the rights are different. So when, let's say, you and your partner, you buy property, you buy a house, you buy an apartment. If you buy that property and you are silent, you don't say anything in the title, it will be automatically tenancy in common. And tenancy in common means that you and your partner own a undivided interest in the property. Meaning that, let's say, my wife and I, we own this house, 50% each. Could be 70-30, could be 40-60, could be any proportion, but my example is 50-50. So when one passes away, their part, the 50% in my example, they will go to their estate, to their heirs, children, our children, for example. The other owner will not get their partner's interest. This only happens in a joint tenancy. So, if you want to buy property with someone else, with your partner, for example, and in the event that one passes away, both of you want that the other retains the full title of the property, you should then opt for joint tenancy. Because in a joint tenancy, when one dies, the other is the owner of the whole property. In tenancy in common is not like this. In tenancy in common is if one dies, their part, their proportion, their interest will go to their estate, to their heirs. Okay? So that's why it is important to know ways you can own property together with other people. Question here, do you have to be a certain age to own property? No, you do not. However, if you are a minor, you would have to be represented by either parents or a legal guardian to either buy or sell the property. No, but there's no requirement of age to own property. Okay? So I want you to practice this. Based on this tenants in common and joint tenancy, I want you to practice here. Okay, so you're saying B. What does B read? So John will get lot A. Lot A. Lot A is owned as joint tenants. So just moving back here, when something is owned as joint tenancy, when one dies, their part goes to the other owner. So A is not correct because when the father dies, because lot A was owned as joint tenancy, the father's part will go to the mother, to the wife. So the husband's part will go to the wife because they are joint tenants. So B is not correct because of this. C, what does C say? Mary will get all of lot B. Why all? So lot B is owned by husband and wife as well, but as tenants in common. So C is not right because C is saying that Mary will get all lot B. No, Mary will keep on. Sorry, Mary, the daughter, will get only the husband's, only the father's part in lot B. Mom, the wife, will still keep her part in lot B. So C is not correct either. E, Mary will get her father's interest in lot B. This is correct because lot B is tenant in common. So only her father's interest will go to her as per the will. John will get no interest in A. That is also correct because the husband's or the father's interest in A will go to the wife because they were held as joint tenants. So this is a good example of a father, of a husband who probably didn't know much about the law and did not consult with a lawyer, was in a very good faith to share their property with both the son and the daughter. However, the husband didn't know that by owning property as joint tenant, even if the husband left that property to one of the sons or daughters in a will, that would not be effective because of the type of ownership as joint tenancy. Okay, so that's why it is important in some situations to either research yourself or to check with a lawyer what your rights and consequences are. Is this clear? So E is the right answer. Okay? All right, moving on. So option agreement, we already saw this in contract law. This is the agreement that you buy time. Remember, 30-day period, 30-day option agreement, 60-day option agreement. So you are not buying the property itself, but you are buying time so that the purchase offer remains open, exclusive for you, until you secure mortgage, until you make your mind, etc. And there's also another type of transaction that is known as agreement for sale. So the agreement for sale is known as a two-stage, two-step process. Why two-stage? Well, first one, you come into an agreement for sale of a property in the future. So this agreement, in this agreement, you will be paying for the property for 5, 10, 20 years. And when you make the last payment, then the property will be actually transferred to you, will be sold to you. This is used with developers, with construction companies that are strong financially, and they offer their own financing tools for potential purchasers. So you don't need to get banking mortgage. So what happens is, in other words, if I have an agreement for sale of my house, it means that upon the first payment or down payment, I get possession of the house so I can start living in the house. And then I will be paying for 5, 10, 20, 30 years, as long as it is negotiated. But I don't have the fee simple of the property yet. I will have it upon the last payment of the agreement for sale. And then once I make the last payment, the seller is obligated to transfer the fee simple to me. and then I already have possession of the house. I will get then the property rights. The fee simple will be finally transferred to me. So that's the agreement for sale, also used. By the way, how do we buy land? How do we buy? How do we get fee simples transferred? Well, we have an agreement of purchase and sale because we are purchasing and the owner is selling. And here in BC, this agreement of purchase and sale has to go through a system, and in BC it is the electronic system. It is known as the land title system. So in this land title system, everything that happened with a specific land will be recorded there. So if you want to know anything about a property, about a land, you would get a copy of the title of the land. In that title, everything related to that land will be there. If there are any restrictive covenants, if there are any easements, if there are any states in that property, anything, who is the real owner of that property, etc., etc. So before purchasing land, you should be diligent and analyzing and checking the title of the land you want to buy, the title of the real property you want to buy. And the government, they guarantee the title, meaning that because they process all documents while fee simples are being transferred, if you have any problems based on a wrong information that is on the title, the government is liable. There's a fund that is used specifically to protect land, real property purchasers and sellers for title mistakes, title issues. Okay, so title is very important. Can anyone get access to land title or only owners? Well, I'm not 100% sure here, but I would say if you have the code for a specific land, I'm afraid you are able to have a copy of the title. I'm afraid the title is public information. However, I just don't know if you actually need this specific code or if you just go to the title system branch and give the specific address, they may be able to provide you with a copy. Okay, I'm not 100% sure, but as far as I know, you could get it. You could get it in the title branch, land title branch. Uh, Two types of properties, condominiums and cooperatives. Most cooperatives, by the way, in BC, they are owned by the government. Not all, but most. But what is a condominium? Well, a condominium, like a strata, condominium of townhouses or apartment buildings, it means that in a condominium, the owner will have ownership of their unit, the unit they live in, and they also have common or shared ownership of the common area, the playground, the patio, the visitor's garage, the golf field, etc. So in a condominium, there's two types of ownership: exclusive ownership of the unit you live in, and shared ownership of the other areas, the common areas. And because of this shared ownership, there will be usually bylaws. Bylaws will be rules for good living, good living of all owners in that building. So rules of how to use the common areas, how to keep it clean, what you can do. In some stratas, I know that owners cannot have a barbecue in their patios, etc. So if you are buying property, if you're buying real property in a condominium, make sure you have access to the bylaw before you buy it, because there may be restrictions in the bylaw you are not happy with, and it doesn't help if you only find out after you purchase, because after you purchase that land, you cannot complain about the bylaw. Okay? The cooperative is different. The cooperative, there's only one type of ownership, and the owners, actually in a cooperative, they own everything in common. So even the unit they live in is owned in common by everyone. And in most cases, a cooperative is a corporation, and the people who live in that cooperative, they own shares of that corporation. So the main difference is that in a condominium, there's exclusive ownership for the unit. In a cooperative, there's no exclusive ownership for the unit. All ownership is shared. In a condominium, only the common area is owned in a shared way. Okay, so that's the main difference there. So, question here for you with regards to cooperatives and condominiums. Ajit, I'll answer your question in a minute. Let's just um, get this study tip here, and then I'll answer your question. Which one is the right answer? E. That's correct. E is the right answer. Because ownership in a cooperative is different from a condominium. In a cooperative, there's no real property in the suite. It is shared ownership everywhere. The real property interest in the suite is only in a condominium, not in a cooperative. That's right. So any questions in any other here? Agent, your question. So can you sell a condominium just like a fee simple? Yes, in a condominium, actually, you are selling the ownership in, you are selling both your part in the common ownership plus your exclusive ownership of your own unit. This is what you are selling when you are selling this in a unit. And the purchaser, they will be bound by the bylaws. That's why I told you that when you buy an apartment or a townhouse, you should be cautious about the bylaws. So you should read the bylaws before. Okay? So moving on. Mortgage, I just want to mention here very briefly that a mortgage is, once you get a mortgage to buy your property, there will be a type of a restriction in the property, meaning that the mortgage details will be recorded in the title to protect the financial institution, because the financial institution, they don't want you to sell the property without paying the mortgage in full. So the purchaser will be aware that there's a mortgage to be paid, there's a balance in a mortgage to be paid. And for the financial institution, having a mortgage on a property allow them to claim both possession and property rights if you default the payment. So in case you are in an event of default, they may seize your house, sell it, and then recover the balance of the mortgage and any other costs they had. And if there's a surplus, they will give you the surplus. But if there's still a debt remaining, which is not so common, you still have to pay that debt. Okay, so a mortgage is a protection for the financial institution in a way that they can seize and sell your house to recover their loss or their balance. Now let's look at household state. So leasing, renting, and this is what I'm going to discuss here with you is more related to commercial tenancy, because in a commercial tenancy, it is understood that both parties in a lease agreement they have access to legal advice, to lawyers, etc. So the law doesn't protect much the tenant in a commercial tenancy. The law protects more a tenant in a residential tenancy, because in a residential tenancy, it is presumed that the tenant is the weakest party in the relationship. But here I will be focusing more on commercial tenancy. So in a commercial tenancy, the tenant, the lessee, will have exclusive possession of the property, meaning that the landlord cannot be bothering all the time to inspect the property. They have the right to inspect, but as long as it is not excessive, it is reasonable. Okay? When the lease is ended, the landlord has the right to get possession back of the property. This is known as the reversionary interest. In other words, the right to get the possession of the property back. And the leasehold interests, they will run with the land. So if you ever, I told you this when we discussed about the contract concept of privity of contract. So I told you that if you are a tenant and the property you live in is sold, in principle you should not be worried, because tenancy rights, leasehold rights or interests, they run with the land. You still have the right to be a tenant there. So the term of the lease could be a term lease for a specific period, or periodic lease, such as week to week, month to month, could be year to year, etc. And subletting is when the tenant sublets part of the property to someone else. Let's say I have rented the whole building, but I don't need the whole building for my company. I can sublet some floors or portion of the floors to someone else. In commercial tenancies, this is very common to be able to sublet. For residential tenancies, in most cases, landlords they prohibit tenants to sublet. Rights. So the landlord they have to offer the premises ready for the tenant to use. So there cannot be any restrictions, any repair to be made. It has to be ready. And also the landlord cannot interfere with the tenant's use of the property. And for commercial tenancies, the landlord has no general obligation to repair. So when there's an issue with the property, it is the tenant that is responsible to repair. This is different for residential tenancy. In a residential tenancy, the landlord does have a general obligation to repair. Okay. The tenant has the obligation to pay the rent. They are not responsible for what is reasonable wear and tear. So let's say the floor becomes old, the carpet becomes dirty in a reasonable way. So reasonable wear and tear is okay. The tenant is not responsible. So in case there are any breach in the tenancy relationship, uh, the landlord can sue for overdue rent, can also sue for breaches, damages, seeking damages in breaches, and the landlord can force the tenant to vacate the premises, by either changing the locks or seeking an eviction order in court. Changing the locks is not allowed here in Canada for residential tenancies, but in the US it is. You may recall some American films you have watched. There's usually a policeman that has issues with alcoholic drinks. They are usually divorced, and they get home late, drunk. They try to unlock their door, and the key doesn't work. And then the landlord comes there and say, "Hey, I changed your lock because it's been 5 months or several months since you last paid me." So in the US, it is possible to change locks for residential tenancies, but not here in Canada. In Canada, you can't. For residential, no. You can for commercial ones. Also in commercial tenancies, the landlord can seize the tenant's property if they don't pay for rent, and then they can sell this property to recover their losses. And you saw in chapter 5, occupiers liability. So the tenants, they are liable for any harms or injuries that are caused to guests in their property. It is not the landlord that is liable. It will be the tenant that is liable based on the Occupiers Liability Act. For residential tenancies, I just want to share this slide with you. So as I said, there's a lot of protection for the tenant because the tenant is presumed to be the weakest party. And you may want to log on to this residential tenancies branch website where you see a lot of templates for forms, agreements, etc. By the way, in this COVID-19 period, rents cannot be increased. Rents, the rate of increase is determined by the government. If I'm not mistaken, for this year is 2%, but it is suspended during the COVID-19. So you cannot have had any rent increase since March, if I'm not mistaken. And there's no right of distress, as I said. Remember, distress is seizing the tenant's property. This is only allowed for commercial tenancies, not for residential tenancies. And security deposits. The maximum amount allowed is half of a month's rent. I know that there are some landlords that ask for 1 month, even more than 1 month rent as a security deposit. That is illegal. It is the maximum amount is half a month's rent. And if you have any issues with your landlord, you can also, here in this website, you will find settlement tools. So the tenancy branch, BC tenancy branch, they have their own their own dispute settlement tools whenever you have issues with your landlord because of this protection. So now looking at personal property, and by the way, we are not going to protection of the environment. So we are almost in the end, not in the very end. So it's not going to take too long from now on. Does the house insurance cover renters? No. Usually the landlords, they have property insurance that is mostly against fire. But for your own belongings or for issues that take place during the tenancy agreement, such as leaking, or let's say someone forgot the gas stove fired and then it caused fire. So for negligent acts of the tenant has to buy property insurance. Oh, sorry, has to buy insurance. And landlord, they may require tenants to have insurance to cover issues that take place while they are using the property. Okay. So in terms of personal property, not a lot to share here. You already know chattels, they are movable things. Examples, devices, clothing, even animals, they are known as in-law. They are chattels, they are movable things. Fixture will be a chattel, will be a movable thing that becomes attached to the land. So let's say you purchase this big safe, big vault, because you have become a millionaire, billionaire, and you want to keep a lot of cash in your house. So the vault, the safe itself is a chattel, but then because it's a big one and you want to hide it in your house, so you permanently attach it to the house. So this is an example of a fixture. So that fixture uh, may only be taken out, it will be incorporated into the building, but may only be taken out if you keep the same characteristics of the property. So fixture, in other words, a chattel that becomes part of the real property. Finders keepers law, simple and straightforward. If you find something in a public place, you can keep it. However, if you find something in a private place, you have to give it to the owner of the place. So at PCAT campus, if you find something, you have to return it to security. However, on the streets, if you find something, you can keep it. The only person that has the right to have it is the real owner. However, you, the finder, you don't need to look for the real owner. But if the real owner learns that you are keeping their goods, they have the right to claim over you. Okay, so that's the finders keepers law. Question for you. All right, so the right answer is C. So when you find something in a public place, you are entitled to that property over everyone else except the rightful owner. Yes, so C is the correct answer. Any questions here? Any doubts? So moving on. Bailment. What is bailment? Bailment is a legal concept that one person or one company, they have temporary possession of personal property. So they don't have the property. They don't own the goods, but they have the temporary possession. So the bailee, sorry, is the person who has the temporary possession, and the owner of the personal property is the bailor. So, for example, when you borrow a book from the library, you are a bailee because you just have possession. You don't own the book. You have possession for some time, and then you have to return it. Okay, the bailor will be the library, and bailees, those who have temporary possession. So you, when you borrow the book from the library, you are liable if you are negligent with the book. So if you spill something in the book, if you tear pages, you are liable. So you have to exercise duty of care. And bailment can also take place for value. So when, for example, goods are being stored or repaired, parties, they will derive a benefit from this bailment transaction. The same thing for carriers. So when DHL, FedEx, Canada Post, when they are transporting goods from, let's say, the seller to the buyer, they are in a bailment relationship. Why? Because they have temporary possession of goods that don't belong to them, but they are liable for any damages that take place to those goods, even if they are not negligent. And to diminish their risks, all those companies, not all, but I would say most, if not all, will have liability insurance. Okay? And we have gratuitous bailment, so free bailment. This is when one does a favor to the other. So in this case, only one party will get a benefit. So let's say I want to borrow your smartphone to make a call because my smartphone is dead. So I'm the only one having a benefit. So that's why it would be a gratuitous bailment. You are making a favor to me. There's also involuntary bailment. This is when someone forgets their personal property. They leave personal property uh, somewhere. For example, umbrella at a bar or a coat at a bar. So the place, the business, they will have to be careful. They will have to take care of the goods after they learn someone has forgotten them, and they have to return to the owner, to the bailor. The business would be the bailee because they are keeping temporary possession of goods that were forgotten there. All right, so last question. All right, so which one is right? A. Let's see. This is an example of a gratuitous bailment. Yes, it's just a favor for the benefit of the bailee. Who is the bailee? Bailee is the one having the temporary possession. So Harry is looking after the valuable violin. Is Harry taking the benefit or is Jane taking the benefit? So Harry is having the temporary possession because Harry will be looking after, but the benefit is actually for Jane, for the owner of the violin. So this is actually, the right answer is actually B, because the benefit is for the bailor, for the owner, for Jane. Jane is the one benefiting from this situation because she will have someone, her friend, looking after her valuable violin. Okay, so Harry is just making a favor. Harry is not making is not taking any benefit. Is this clear? So just to emphasize, yes, it is a gratuitous bailment. However, the one benefiting here is the bailor. It would be A, in case Harry wanted the violin borrowed from Jane to use, to play, to play. But this is not the case. Harry is not asking for the violin. Harry is just being asked to look after the violin. That's why it is for the benefit of the bailor. All right, so as I said, we don't go over protection of the environment. So similarly, as I discussed with you in chapter 12 for unionized places, this part here will not be examinable. This part here will not be in your final exam. I just want to tell you that protection of the environment is an important issue in business. Let's say you want to buy land because you want to start your company there, you want to have a manufacturing plant. You may have to look at environmental law, whether it allows your core business to be performed there if you do not work with gases or any other substances that are prohibited. So I would say that environmental law is relevant in business. But here in business school, we don't work with them. You still have the slides and the textbook parts, but if you if you're interested in reading more, but we don't discuss them. So that's chapter 14 for real property and personal property.